Thank you for joining us once more. Welcome to Work Comp Talk, a podcast dedicated to injured workers in California, giving you all the tips, tricks, and information you should know when it comes to the workers' compensation system here in California. My name is Carmen, your host, and joining me today is my co-host, Bilal Kassam, who is done traveling, thank God, done being sick, and is here 100% well today. Last time you were a little bit sick, right?
A little bit.
Just a little bit. He's been doing workers' compensation for God knows how long. What, 9 years? 10 years?
Over a decade.
10 years plus.
Yep.
And obviously knows everything that you need to know when it comes to the system. So who better than to ask what we will be talking about today, which is how the California compensation system is supposed to help an injured worker, but it doesn't. So there's a lot to kind of break down when it comes to what the California compensation system is supposed to do. So how about we start with that? What is the workers' comp system supposed to do in the first place? Like, what are the brief overviews you can give us when it comes to the system?
So when you're talking about California workers' comp, what you're really talking about is a benefits delivery system. Mm-hmm. It's not meant to be a litigious system where people fight. It was supposed to be a way to get injured workers benefits, both financial and medical, as quickly as possible to make sure they were taken care of and then put back to work if possible. And also to limit the exposure of the employer because, let's face it, injuries happen.
Yep.
And sometimes the injury is due to something or someone stupid doing something stupid, or sometimes it's just a freak accident.
Right.
You know, everyone did everything right and it was just a dangerous situation. You see that a lot, you know, in the course of, you know, police officers doing their job or construction workers, chemical material handlers. There's a lot of potential risks there that even if you do everything right, there's still an accident. And the system was really designed in order to protect employers in those instances from being sued in civil court for damages because the legislature thought, you know what, hey, look, accidents happen. We shouldn't punish the employer for those accidents.
Right.
But at the same time, we should make sure the injured workers compensated. And so they had this grand bargain back in the day, and that was the trade-off. Injured workers gave up their right to sue in tort and civil court for workers' comp as a system.
Which was essentially meant to be able to protect both sides, the employer and the employee, and it's supposed to be a good one-size-fits-all type of benefit, but it's not.
No. You know, the whole idea behind insurance, everyone may have a different opinion on this. You don't have to agree with me. That's fine.
And a different experience. There are those who, and we just talked about this prior to the episode recording, there's been people that go through the system and they have completely great outcomes and experiences within the system. However, those are smaller injuries that I've noticed.
Some, but I mean, the whole issue of there being a middleman, like take a look at credit, right? As soon as Americans could start putting everything on credit cards, prices go up because the gist of it is, oh, well, I don't have to pay for it now. I can pay for it over time. And even as things get more expensive, you know, I can just keep putting it on credit. Mm-hmm. And if things weren't on credit, there was no option for credit. People had to pay cash for things. There'd be a lot less purchasing. Prices would be moderated by the market and people's ability to pay right then and there. And so, you know, it's the same thing with insurance. When you get insurance as a middleman, it's just another layer of complexity and another reason why, at least in workers' comp, you know, things cost more, things take longer, you know, and in particular with insurance in the United States, California, is for profit. These
They're all for profit.
Private, nonprofit entities. These companies are designed, and they're mostly publicly traded, to generate profit for their shareholders. And that's how CEOs and such are compensated, right? Make companies more profitable, make more money. And in the case of insurance, you're not delivering a public good by saving money, right? You're depriving people of their public goods. You're you're taking away their ability to get medical care, taking away their means to pay for their rent, their food, their family, and such. So when you're talking about insurance companies being profitable, it's at the cost of the injured worker.
Unfortunately.
And so inherently, when you have a system where there's a for-profit company responsible for delivering benefits, they are at the core of their business incentivized to not do that very thing that they're there for.
Exactly. So we're going to talk about the benefits, and we're going to dive into that in a little bit. But first, after us understanding some of this system that was set into place to favor both sides, right? It was supposed to protect the employer and it was supposed to also protect the employee. This is just in California. We live in the United States. There's so many different states that have different regulations, different laws. I've heard, and you can correct me if I'm wrong, that California has some of the most worker-friendly laws that favor when it comes to injuries at work. Is that true?
I would say so, at least based on my knowledge, that I know of. Granted, I'm not familiar with all state laws regarding workers' compensation. I do know that workers' compensation in California has been historically, I'll say this with a grain of salt, favorable to the injured worker. But, here's an example of this. We used to represent pro athletes in their workers' comp cases. We did a lot of work for NHL, NFL, NBA, and some MLB players. Ton of cases, hundreds and hundreds of these cases, and all the players would come to us from out of state because we had very favorable laws here, so we could file their claims here in California if they played games here or played for California teams at some point in their career. Mm-hmm. That changed, but that's just an example of California laws specifically being far more favorable to the injured worker. And California in general has always been historically known to be employee oriented as a state.
Right.
If you're an employer out there and you're listening to this, I'm sure right? California can be a headache sometimes from the employer's perspective, but it can also be very, very favorable to employees with a lot of protections for employee rights, including workers' compensation.
Okay. Such as the presumption laws that we have here in California for certain diseases.
Yeah, we have presumption laws. We have what they call cumulative trauma cases, which are long-term wear and tear cases. Some states don't recognize cumulative trauma cases. You can't file them. They don't exist.
That sucks. And it happens. Wear and tear does happen, just like anything else. Imagine if you are working for, mail carrier, you're a postman, mm-hmm. and you're constantly dealing with walking because you're delivering everyone's mail every single day. You walk more than anyone else does, and your knees start giving up, and your ankles start giving up, and you start getting all these injuries on your legs, and it's just like, that's where... It's kind of like a car. You're driving a car everywhere. The tires are going to give out. Yep. Someone's feet are going to give out. But anyways, that's, I guess you could say, a brief overview of what someone can expect or should expect, but in the reality of when it comes to the workers' compensation system here in California. Let's dive into some of those benefits that you mentioned earlier. They gave up the opportunity to sue the employer and say you're at fault and try to go after all their money to be able to obtain some sort of money to then protect themselves. In the system now, you have access to, or you should have access to, what they considered at one point high quality medical care. You laugh.
Yeah.
Why?
Well, so workers' comp, it's not at least in terms of the medical, right? It's not you get hurt at work, so go treat with whoever you want, right? Like if I go hurt my back, I can't just go to the best doctor at Stanford and get care free, right? That's not how it works. So they have what they call medical provider networks in workers' comp, which are networks where there's doctors that are approved to see workers' comp patients for specific carriers. And so the work comp networks are something that's built into the law, and as long as the carrier follows certain rules, they can have these networks which limit the type of doctors that you get to see and who the doctors are and where they are and such. So, really when you're talking about the medical care and workers' compensation, you have to operate in this closed universe. And even if you find a doctor you like in the network, not all treatment's automatically authorized. We have something called utilization review, which is the process by which the insurance company says yes or no to your doctor's request for authorization. So your doctor can want to give you back surgery, but the insurance carrier could say no. And so you have to fight an appeal and go through certain hoops to actually get it, but you may not. And so it's much different than going to see your own doctor, where you just go to your doctor, they prescribe you medication, they send you to the pharmacy same day, you go pick it up and you're good. The process is complicated.
And this is supposed to be the high quality medical care you're supposed to get when you get injured within the system. However, the doctors are handled by the insurance company. It's a whole massive kingdom of, they control a lot of shit. You still get the last word from the insurance company. Like, they're not the doctors. How are they going to say yes or no to your surgery? Please, like, what the
Well,
F?
It used to be different. Back in 2013, we had IMR introduced, which is independent medical review. And this came with changes to the law around the time. Basically, eliminated the doctors from fighting over whether or not things were medically necessary. Back in the day, we used to go to the doctors to make the final call on whether or not treatment should be authorized. But since the system changed, we're left with this appeals process that's less than great. And that's our only avenue. And
That
so
sucks.
if the insurance company says no, we get to appeal through IMR. If IMR says no, then, it's dead in the water absent some change in circumstance. But, I think the major problem with workers' comp, at least from the medical perspective too, is that we have something in California called the official medical fee schedule, which sets the rate that doctors are paid for various forms of medical treatment. It dictates how much they get paid for an office visit, for prescribing medication, durable medical equipment, or performing surgeries and lab fees. All those things, they're all set by statute. So unless those rates change too, doctors are fixed by the amount the insurance company is legally obligated to pay them. And the lower that number gets relative to the doctor's cost of doing business, the less likely it is you'll have higher quality doctors wanting to continue to see workers' comp patients.
Yeah, if they're taking a cut and it's actually affecting their business, it's not going to help out.
Yeah, and I mean, I know certain doctors, they're phenomenal doctors, but I think they choose to do certain types of work because they can afford to, versus, some types of work may not necessarily be, I don't want to say profitable, but, enough to keep the lights on, right? Because medical practices are businesses too, right? The medical staff, the rent, the equipment, salaries, healthcare, benefit, all that stuff costs money. You can't, not all doctors' offices are nonprofits just treating people for free. They can't. It's business,
It's impossible. So the quality medical care that they presumably tell you once more in marketing brochures, like, yeah, we're going to take care of you, may not be the quality medical care that you're thinking you're going to get. However, there are some instances when you go through that MPN list, and like you said, some good doctors are in that list because they want to perform certain things that they have no issue performing when it comes to the system. And we've even mentioned it in previous episodes. When you know what the good doctors from that list are, you want to favor them, you want to choose them, you want to change with them, because your outcomes have a better chance of giving you a better future than if you chose a random doctor who's not favoriting the injured worker.
Yeah, and as much as the doctors are incentivized by, performing treatment procedures that are profitable, they're also incentivized not to. There's doctors that are more favorable to the insurance companies, and the more that they can limit costs for the insurance company, the more likely it is the insurance company is going to send more patients to them. Of course. And so you have these clinics and facilities that are favorable to the insurance company, not the injured worker. And the name of the game is to get the person in and get them out as quickly as possible and back to work, so that so that the insurance company, doesn't eat the costs long term.
As bad.
The funny thing is, though, I'm going to put on my defense hat from back in the day for a minute.
Do what you got to do.
If the insurance company actually just gave people a little bit of treatment, gave them the time of the day, were polite to them, were respectful, were empathetic, kept them off work for a little bit, just paid them some temporary disability, gave them a break to get better, long term, the cost would be much lower.
They would save so much more money.
Long term, probably far less people would come to me for help if they just took care of people a little bit more. And they don't have to do everything. Just do a little bit more, take care of that person. Give them a few weeks or a few months off of work. Give them the treatment they need to get better immediately, rather than dragging it out for 2.5, 3, 4, 5, 10 years.
Shit, dude, for real.
So
a little does go a long way, and I'm with you on that.
What's the saying? Shit, I can't remember what it is. It's something like a penny rich, pound foolish, or something like that, right? Like, you're trying to save $1 and you end up spending 100. That seems to be the insurance company's perspective.
It's kind of stupid, but that they use that tactic in the sense of, you're right. If they would literally just have a little bit more empathy and just cut someone a break, they would probably save millions. But again, who am I to say, right?
I don't run insurance companies, but insurance companies, if you're listening and you want some advice, call me.
Got your new GM. I'm just kidding. Okay, so let's talk about the temporary disability benefits that they're supposed to get. Ideally, temporary disability benefits are meant for you to get compensated while you're recovering for your injury. Mm-hmm. However, ...
So there's limits, your doctor has to certify you. You can be temporarily totally disabled, which means doctor says you can't work at all, or temporarily partially disabled, which means you have work restrictions. if you have temporary partial disability, it's up to the employer to determine whether or not they can accommodate you and keep you on doing modified work. But temporary disability in California is limited to 2 years total. It can be paid in broken periods, or it can be paid 2 years solid. And it all has to happen within 5 years from your date of injury. There are some exceptions where temporary disability can be paid up to 240 weeks. That's rare. High velocity eye injuries, amputations, HIV, other kinds of serious long-term chronic conditions would be exceptions to that rule. But even then, you have minimum rates and maximum rates. And so the maximum rates generally adjust up or down every year. And if you make far more than the maximum rate, your temporary disability rate is limited to the maximum rate. So you could be losing a pretty substantial portion of your income.
And let's be real, there's times where they just don't flat out pay you. They don't pay you, they delay the payments, they come up with all these excuses, and then you're left with no fucking temporary disability benefits. So,
which I think, is an example of how long it could take to get temporary disability. Like, let's say you filed a case and you actually got hurt. Like, let's say you slipped and fell on your back. The insurance company talks to the employer says, oh, they just made it up, it never happened. Insurance company denies liability for the case. Then you hire an attorney. I have to go investigate, maybe take depositions, maybe send you to a QME examination, all which could take months. But once done, then we have to file for a hearing at the Workers' Comp Appeals Board to get to a trial. Then we have to wait, a month and a half, 2 months to get to a trial. Then we potentially have to wait for a decision. You could have someone who files a case and gets denied and has to fight it out, 6-9 months potentially before they start getting temporary disability if everything goes pretty smoothly in terms of like process of getting things done and getting to trial and getting a trial decision. So that whole entire time, that person, maybe they have SDI to rely on, but if they don't, they're screwed. They're sitting there with nothing. They
eat and drink air.
Yep. And the insurance company's sitting there, they're cool, multi-billion-dollar company. They're all getting paid, but the injured worker's not. And I think that's probably the most frustrating part for us as attorneys, is having to go through the system and it being as slow as it is to help people.
And I'm assuming that also falls into place with the permanent disability benefits that are supposed to be advantageous for someone who's injured. And according to what we've read and some of the stuff that I've learned from other states, California does provide permanent disabilities. Other states don't even provide that. So we're supposed to be lucky that we get permanent disability.
Yeah, so insurance companies are liable for permanent disability if there's residual functional impairment that can't be fixed through medical care. And ultimately that's assessed at the end of a case once someone has medically plateaued, meaning the doctor can't do anything else for them. And yeah, here's the thing though, permanent disability, it's a bit of a misnomer. It doesn't actually mean you get benefits for life. In most instances, there's some exceptions to that if you're high enough in disability. But the permanent disability is based on these formulas. They call them rating strings, and they're supposed to represent like how does this injury long-term impact your earning potential and your ability to compete in the labor market and such. But it doesn't. You could have, let's say, a 5% permanent disability rating for a torn meniscus in your knee, which can be painful and affect your ability to run and do a lot. Let's say you're a police officer and you need to be able to run after people.
Of course.
Right? Or you're a firefighter, or you're a construction worker and you rely on your ability to run or climb or stay on your feet for a long time. Even though you have a small level of permanent disability, that can put you out of your career. And so the compensation for the permanent disability at 5% is I'm spitballing off the top of my head here, but I think it's $5 or $6 grand, maybe something like that, maybe less. So it's cool, you lose your career and you get $5 or $6 grand for permanent disability.
Horrible.
Because you have work restrictions that are, even though the permanent disability is relatively minor, puts you out.
That sucks.
So we see that a lot too, where people are displaced from their jobs and their careers with a very low level of permanent disability. But now their earning potential is completely screwed because they're committed to that particular career field because of training, experience, and age and other things, So even though permanent disability is supposed to be there to compensate you for your lost earning potential and the effect of that injury long term, it totally doesn't.
Yeah.
And even then, permanent disability rates haven't changed since 2014. So they're still $290 a week, which is like nothing for a lot of people.
Literally. What are you going to do with 290s?
Yeah, you can't,
Sucks.
At least in the Bay Area,
Cell phone. That's about it.
Maybe your cell phone, but, it's a big problem.
It is. Now, speaking about permanent disabilities and you getting out of your career, another one of the benefits that, the California workers' compensation system is supposed to provide and is supposed to help you out with, but sometimes it doesn't, is, vocational rehabilitation, retraining to help you return back to the work field when you can no longer do the job that you were doing prior to. So how is it that some people do get vocational rehabilitation and others are not even qualified for it?
So vocational rehabilitation is kind of an old term of art from way back in the day. Vocational rehabilitation as a term itself doesn't exist anymore, but we have something that was born out of that.
The voucher.
Yeah, we call it the voucher, or SJDB, Supplemental Job Displacement Voucher, or benefit. And what that is it's a payment for, it's a voucher for reimbursement for up to $6,000 in re-education or job retraining or related expenses. And that comes about if you have permanent disability and you don't receive a permanent offer of modified work within 60 days of being deemed maximally medically improved. And so you could have a situation where someone has permanent disability, but maybe they don't have much in the way of work restrictions. They're still entitled to the voucher. It really comes out of the fact that they have permanent disability and there's no offer of work that was made that lasts at least 12 months following their MMI date. $6,000 doesn't go a long way. I'm sure we all see the cost of education
it's like
in schools and stuff.
If you're taking one class, per semester, and you're paying out of pocket, that's like $900,000 for just that one class in one semester, which is literally 8 to 12 weeks, 3 months.
I think the voucher probably gets you maybe like a good year of community college, including related expenses, maybe, depending on your caseload.
Depending on what you're studying. If you're going to be like let's say you want to go back and, I don't know, become a phlebotomist or a medical assistant, there are career colleges that won't cost that much, but still, you have to continue to invest in, retraining and all that stuff, and it does add up. So it depends what type of career.
The state does have a piggyback benefit, though. It's called the Return to Work Supplement, where if you get the voucher from the insurance company, the state will pay you an additional $5,000 that you can use for whatever you want. If you want to put that towards, your education, that's cool. If you want to go, I don't know, take a vacation, I guess you could use it for that too. But, it's kind of a smaller benefit that the state provides. Again, not the insurance company. That's supposed to help out a little bit for displaced workers.
That's something. It's better than nothing. So I guess it's favorable. Before we move on to the next subject of what you're supposed to be getting from workers' comp, but sometimes you don't, we do want to say this isn't the case for everyone. Again, I keep saying there are people that go through the system and might be listening to the podcast and are like, these guys are full of BS. Like, that is not how it goes. There's different circumstances, and some people can go through the system with no issues and they favor them, and it happens. I'm not saying it doesn't, but we talked about the permanent disability. We talked about temporary disability. We talked about the high-end medical care you're supposed to get. And of course, the laws that apply to California and not other states. So we should feel lucky that, they do. What about protection from retaliation? Meaning your boss is supposed to not let you go because you were injured. However, recently I was going through some of the comments in our podcast, in some of the videos, and there was this one gentleman in particular that was given a question and said, I was injured. Apparently he had gotten hand, foot, and mouth disease, which is so funny because I've heard of that through my kids' school. And he apparently had gotten it at work. Of course, that shit takes forever to go away sometimes. And he was out of work for about a good 3 months, from my understanding, to some of the stuff that he was sharing. He got let go because he didn't go to work for those 3 months. But he couldn't go to work because it's so contagious. You give it to everybody else. So it's like, how does that come into play? Like the retaliation, like you're supposed to be taken care of, but does that happen?
So we have something in California called a 132A claim, which is a claim that you were discriminated against or retaliated against because you reported a work injury or you made known your intention to pursue a workers' compensation claim. And the standard of proof is sometimes pretty difficult, I think, especially when it comes to what we call the he said, she said arguments, which is, the injured worker claims that the boss did something to them or said something to them, but there's no documented evidence of that. And the boss says, I didn't do that stuff. I never said that stuff, which ultimately means that when it comes down to trial, you have a trial over whether or not the injured worker is considered a more credible witness and the judge believes them versus the boss.
Yikes.
And sometimes that can be very, very difficult. And some people are very sophisticated as employers and they know what they're doing when they're discriminating against someone or retaliating someone. And they don't have everything written in paper. There's no smoking gun. There's no email where it's put in writing and memorialized forever, and it can be difficult. We've had cases, and I think we've talked about this before, where it's just blatantly obvious that there's discrimination and retaliation. 100%. It's someone wrote something incredibly stupid in an email and sent it to someone or a text message, and it's there, right?
If you say that you got injured at work, I'm going to fire you or I'm going to lower your pay.
Right. And so the issue is like, how stupid is the employer? I'd say most aren't, and most are crafty, and most know what they're doing when they're screwing with someone.
And they've probably done it more than once, just saying.
Yeah. And, there was a term that was popular for a while a couple years ago called microaggressions. I don't know if you remember seeing that all over social media and stuff, but like it's true, I think people know when someone's screwing with them and they called it microaggressions because it's like passive aggressive or it's so small that it's kind of unnoticeable,
right.
But it's there and that something's off and like someone's fucking with you, but like it's difficult to prove that. And you just, as an employee, if you're getting poked at every single day, just little by little, at some point you're going to snap. And that's what happens a lot in these cases where, the employer screws with someone. They're picking at them every day, a little bit by little bit. And then finally, the employees either forced out, they quit, they snap, whatever happens. And it's very difficult to come back and prove those as 132A claims, even though it's just the person knows that's what it is, you know? But yeah, if someone has a discrimination or retaliation case, they have to prove that they were discriminated or retaliated against. Then the burden shifts to the employer, and the employer then has to establish what they call an affirmative defense, meaning that there was a legitimate business necessity for the employment action. So like if you say, hey, I was terminated and it was because they chose not to accommodate my work restrictions, and I'm the only one that they didn't accommodate. Everyone else got accommodated, so they must hate or retaliate against me because of my work issue.
Yeah.
Then the burden would shift to the employer to say, well, why didn't you accommodate those work restrictions?
So then they have to defend themselves.
Right. And if they prove that there's a legitimate business necessity or that they acted in terms with their policy and their policy was non-discriminatory and they've treated everyone the same way, then the injured worker loses that battle.
Yikes. Which is important, speaking about battles.
Yeah.
And we've mentioned this more than once. The importance of not running this 132A on its own. You definitely want to get legal representation when it comes to being discriminated at work. And a lot of people feel that the 132A falls into the workers' comp attorney's hands and there should be no other attorney involved, or some only go to a workers' right attorney, someone who's going to be protecting your wages, etc., time off, and then they don't even bother to go through workers' comp. So it's important to seek legal representation and to clarify, who does the 132A belong to? Is it workers' comp, or is it work rights attorney, or is it both?
Yeah, so there are some cases on this. You said it perfectly. There's some laws that fall under what we call an employment law attorney's purview, like wage and hour, pay stub violations, overtime violations, misclassification penalties, lunch and meal or rest break issues, independent contractor misclassification, back wages, things like that. Also, California's Fair Employment Housing Act, which protects things like age, race, sex, sexual preference, religion, any kind of discrimination based on that, which is not a workers' comp issue. Sometimes they may go hand in hand. Maybe the reason why they're discriminating against someone because of their work injury is because they're a certain race or because they're a certain religion. So sometimes you can have overlapping issues, but the idea that you're discriminated or being retaliated against because of a work injury is a different issue than being discriminated against because you're part of a protected class. And so you may have two different claims going on.
Interesting.
And it may be one or the other or both at the end of the day. But the 132As are strictly workers' comp. Everything else is what you would address in superior court.
So we've kind of discussed a little bit about what are some of the things you're supposed to be getting from the California workers' compensation system. But again, you don't always get. Legal representation comes into hand. When you hire an attorney, how effective is this, and how does this benefit an injured worker to hire an attorney? How does this whole scenario we've been discussing for the past 25 minutes change the game when there is an attorney involved?
Can I be honest here?
Yeah.
Depends on the attorney. Sorry, my other attorney friends out there. We're not all created equal, right? We're ranked in law school. We're ranked in, how well we do. Now, everything's got rankings in life. Whether you're a doctor, a teacher, a lawyer, no one's exempt from that. And there's some good attorneys, there's some bad attorneys. And I think the quality of the representation you get obviously impacts the quality of the outcome in your case. Mm-hmm. And so, I think if you have a good attorney, it can do wonders for you.
Right.
They know the right doctors, they know the right evaluators, they know the law very well, they know procedure, they can be incredibly aggressive on your behalf and hold the insurance company accountable, at least to the extent they can with what the tools they're given in the law. But you can also have a really crappy attorney who just ruins your case for you.
Yeah.
They're not on top of things, right? They're inexperienced, they choose the wrong doctors, they don't advise you properly regarding settlement. They can mess things up for you quite a bit too. I would say probably on average, most attorneys, even mediocre attorneys, are probably going to get you a better result than you doing it yourself.
No matter what.
No matter what, just because, I think there's certain things even the mediocre attorneys are just, they have the knowledge that you don't, even if they're not that great, and they're still going to do a better job.
Yeah. Then because they've studied it, or at least they should have studied it, and this is what they do for a living. Mm-hmm. It's not like you're just going to pick up a book and try to figure out how this works. You can get the basics, but there's more than just the basics when it comes to the California workers' compensation system. Which, speaking of, once, let's just say you do get a good attorney, you do get legal representation on your behalf. Does this in any way, shape, or form speed up the process? Does the insurance company then stop playing stupid and essentially get their shit together, get their act together?
It depends. There's other cases where, I've had clients, quite honestly come to us, and then the insurance adjuster that was friendly and cool before started to become a huge asshole because they retained an attorney, But then it's got the other way too, where someone was getting jerked around, and then we got an amazing result and wrapped up the case for the client, and it was a far better outcome than the client would have got otherwise. One of the examples, I think we talked about this 2 years ago. We had one client came to me strictly to review a settlement offer. It was $40,000, and she had a pretty intense back injury, and I could see in 2 seconds looking at the QME report that the case was worth way more than that. I think we settled it. It was like 4 or 5 months later for like $180,000.
Wow.
Something like that. So it's like, sure, the client came to us, the adjuster was probably okay, but, just with our knowledge base, we were able to get a lot more for that injured worker. And she at the time she wasn't like mad at the offer. She didn't look at the $40,000 like it was trash, but she just didn't know any better. So she wanted a second pair of eyes.
Well, that was good that she looked out for herself on an average too. Yeah. And there has been studies. We've actually placed these everywhere on our website. If you have not yet visited, Bilal is co-founder of Pacific Workers, the Lawyers for Injured Workers here in Northern California. And we've posted this many times where on average, just by hiring an attorney, just by saying I am legally represented by someone who knows the law, insurance companies tend to give 30% more on a settlement than if you were not represented, just by hiring an attorney.
And keep in mind, our fees are 15%. They're not 30 or 40, so that's actually a net increase to you. Some people think we take, sure, they'll pay you 30% more, but your fee is 33%, so it's a loss for me. Well, no, that's not the case. It's 15%, and that's only on average. Like the example I just gave is more than 400% more.
Yeah.
But I think to go back to your question, that's more so. I think where the benefit of the injured worker is, it's not that all of a sudden the adjuster is going to be way nicer and get things done for you. Yeah. You just have someone who knows what's up, who's advocating on your behalf to help get stuff done for you.
To pick those red flags out and be like, yo, this is not how it goes. Like, no, this is not the settlement we want. This is not how we want to go. And this is what you're entitled to. So there is beautiful stuff that come into play when you get an attorney on your side. Not to mention that, you do get that 30%. And it's another misconception. People think that if I get an attorney, where am I going to get the money to pay them? You don't pay by hour for them. It's completely different than, other parts of the law here in California. So maybe you can better explain how the pay system goes when you hire an attorney for workers' comp.
So we're contingency fee based, which means we only get paid if we win something for you. If we get an award for you, then we take a piece of it. It's, like I said, typically 15%. But if you come to us and your case is denied and we fight it out and we lose at trial or something, you don't owe us any money. That's it. We took your case on the risk that we would lose and get nothing. And so we put our time and effort into it. And if we lose, we roll a donut just like you do. We get zero.
We lose together.
There's no fee or anything like that. And, sometimes that's what we're here for. I've had plenty of cases where honestly, it felt like my job was just delivering bad news. And,
Yikes.
It wasn't anything that we did that we messed up on. I think we gave it our all. We fought a good fight, and the case wasn't a good case.
Yeah. And it happens.
And it happens, and that is what it is. My job as an attorney is to be a counselor too. And that sometimes means delivering bad news just as much as it means delivering good news. But I hope at the time I do, there's a level of trust and relationship there where if I'm delivering bad news, it's for a reason. If I'm saying this case isn't good and you're going to lose, it's because I know what I'm doing and I care about you.
Yep.
And I want to see what's in your best interest. And if there's a settlement that's being offered that maybe you don't like, but your risk is a zero on the other end, maybe I'm going to guide you in the way that's going to be best for you.
Yeah. So this is another way for you to kind of recap everything that you're supposed to be getting with the system. And this can go for someone who's already been in the system for so long. Sometimes you forget what are some of the benefits you're entitled to. Sometimes you don't even know what you're entitled to. And this topic in general, and the reason why we chose speaking about this is the beauty of it is letting you know what you're supposed to be entitled to, but you don't necessarily get. It's not what it is on paper. And secondly, someone that just recently injured themselves and who definitely has no clue what they're diving themselves into gives you an opportunity to kind of sit back and really take this information in and figure out, do you really want to mess with, the outcome of this life-changing for some people type of scenario that happens. There's been people that, and we can discuss this later when we share a couple of success stories, but this getting injured at work for some has been life-changing. And it's scary, but as much as it's scary, again, they're accidents, they happen all the time. It's not like you're gonna say, hey, I'm gonna go get injured tomorrow. It's just really, really good to know that, Bilal, you're here to share this type of information and shed light onto the realities of a system that was supposed to be created equally in helping injured workers, but unfortunately it's not. There are new laws every time a new year rolls up. So if we are recording this podcast recently in this 2024 New Year, so I thought, why not also share some recent developments that are coming into play for the law, potential changes that some injured workers can essentially see in this year, and maybe you can give us a heads up if something we should look out for.
So, at least as of 2023, Medi-Cal, which is California's healthcare for low income, which a lot of people are on, used to consider your asset limit. So at least for 2023, you couldn't have more than $130,000 in assets in order to qualify for Medi-Cal. And so
meaning you can't own shit like cars, et cetera, et cetera.
Exactly. Like they would consider what's in your bank account and say, hey, you have too much money to qualify for this, right? Go get your own insurance. And so as of 2024, that asset limit's going to be gone. They're not going to take into account what's in your bank account, basically, for determining whether or not you can qualify for the benefit. And so the whole idea, or why this matters, is because there's a lot of people who are displaced from their employment, which, quite frankly, is the number one source for healthcare benefits in America, right? You get health insurance when you're employed. And so if you're taking a settlement and you're concerned that you're not going to go back to work, but the settlement's going to be counted against your income or your asset eligibility to be able to apply for Medi-Cal and get the care you need after settlement, if that's what you're doing, you're not going to have to worry anymore. It's not going to be an issue.
That's huge.
Yeah, so it's a big issue. That comes up a lot, in workers' comp cases because people lose their insurance. So they're like, well, if I get this huge settlement, relatively huge settlement, am I going to qualify for Medi-Cal? Can I still go get care I need from them? And so the answer is, they're not going to take that into account anymore. So that was a new change in the law for 2024.
Dude, I'm wondering if this is not just going to be something for someone who's going to get a settlement or not. Is this going to be for everyone in general?
Yeah, it's generally eliminating the applications will no longer ask for asset information as of January 1.
Huh. Yep. We will be diving into that topic at some point eventually.
They will consider income though, right? So obviously that still matters.
Yeah, they
but
do,
not
definitely.
asset.
Okay, that's okay. I'll put all my money in your bank account. Just kidding. Okay, so let's talk a little bit about a recap of everything we've just discussed before we call it a day on this episode. Essentially, you're supposed to get benefits. Those benefits include medical treatment, wage replacement while you're getting better. You're supposed to get temporary disability, permanent disability. If you're canned out from your career, you're supposed to get that supplemental voucher that's going to help you kind of take a step back and reevaluate your career and go through a new career path. We've discussed the retaliation, the 132A. Is there anything else that I've missed as far as like what the system is supposed to cover for an injured worker here in California, but doesn't, that we have not mentioned?
Sort of.
I mean, I'm pretty sure a lot.
So there's one other component, they call them serious and willful claims.
Ooh.
Basically, it was a carve out to you can't sue your employer. Right?
Okay.
So when employees gave up the right to sue their employer in tort, we kept something called serious and willful misconduct claims, which means that if your employer knew or should have known of a dangerous condition, didn't fix it, didn't take steps to fix it, and you got injured because of it, you can file a serious and willful claim. And that serious and willful claim makes the employer personally liable for up to 50% of costs or the benefits provided to you is damages. Their claims are very hard to prove.
Right.
And you're looking for things like violations of standing OSHA safety orders, or even just a general sentiment that, hey, everyone at the employer's place of business knew that there was this dangerous condition. We all told the employer to fix it. It's dangerous. Someone's going to get hurt. And they didn't do anything. And then sure enough, someone got hurt.
Or can this also be, let's just say that you were using a power tool and the power tool just so happened to get a recall or was malfunctioning. Can this also go against a company that, let's just say you're a construction worker and there was a recall on a specific type of hammers that weren't properly built, and you're hammering something and the hammer head just freaking flies off the little handle and you kill someone, or God forbid, does this fall into place into that little scenario as well?
Maybe. I don't want to get too technical, but if your employer knew about the recall and kept you using the equipment, that could be serious and willful misconduct.
Gotcha.
If there was a recall that came out and, before anyone could do anything, there was an injury that happened because of the malfunctioning tool, the workers' comp system doesn't eliminate your right to sue a third party for their negligence. So if you get hurt on the job because of, they call it products liability or product defect, or you get hurt on the job because you're at a third party job site and there's a dangerous condition there, you can sue them. If you get into a car accident traveling from one job site to another and it's a third party that hit you, you can sue them. So you still have the ability to sue third parties and pursue workers' comp at the same time, although you can't double dip in the end, but you have two different avenues to recover for different things.
Interesting. And again, you just mentioned the whole you can't double dip when you are going to do a third party lawsuit and you do workers' comp. And that's a whole nother topic that we can add into our inventory of episodes. So I promise you we will start shedding light into those because there has been a lot of questions. People have asked the difference between having a personal injury and specifically when it's work-related injuries, when you're driving a company vehicle and you get into an accident with another person. But that's another episode for another day. I definitely think this sheds light into essentially what workers' comp was supposed to do for an injured worker, what it should have covered, what it does cover sometimes, but not really. So if there are any questions that we left out that you might have, please feel free to drop them in the comments below. If you feel that we touched any part of the subject that hits home and it's something you're currently going through and you would like to get a free consultation, you could definitely hit up Bilal and his team. There is a total of 10 attorneys at your law firm, and they work and have been working for many years and have helped many, many people. I think, if I'm not mistaken, the recap of what circled back for 2023 was... it was an average of, I forgot, what was the amount of money that you guys settled in 2023 for injured workers, what you guys recouped?
High 30s, millions, something.
Yeah, it was definitely in the millions.
Somewhere between 30, 40 million.
I'm trying to look for it, but I can't find it. I promise you I'll drop it in the descriptions. But they obviously know what they're doing. They obviously are here to help you if you are in California. You can go ahead and give them a call. It's 800-606-6999. You'll be connected to an intake specialist who knows how to ask the right questions to kind of guide you and help you figure out your next move. They connect you with the attorneys. You can ask an attorney directly some of your questions if you feel you trust enough and you want the team to handle and help you walk through this whole system. Then you retain their services and you don't pay anything out of your pocket. As we mentioned earlier, it's contingency fee. You get paid. The attorneys get paid from your settlement afterwards. And if you lose, they don't get anything as well. So there's a lot of benefits that you guys provide. There's also a pocket guidebook that is out there if anyone wants to kind of skim through what is it really like, what are your rights and your benefits. We do have an ebook that you can download. Just go onto the website, pacificworkers.com, scroll to the middle of the page, and you will see download our ebook. It's going to ask you for your email, and then it'll send it to you via email. We have it in Spanish as well, and you can just go to our Spanish version of the website. And again, if you find this information helpful, useful, please, I urge you to subscribe to the channel to keep learning every time we dump new episodes, we talk about new things, and follow us on social media, because we do have the podcast, but we also have a YouTube channel for his company, Pacific Workers, which contains different information as well. Sometimes I forget to share information on both channels, but it's very important for you to follow both of them. There's so much to learn. If you're not a YouTube guru, we have TikTok. If you're not TikTok, we have Instagram. I still highly suggest YouTube be your go-to, but definitely subscribe, hit the bell notification so you get notified. But yeah, this was fun. Thank you for sharing all that information, and we'll catch you guys on the next episodes. And don't forget to leave your comments.